2 that the hearing of this case has not started and no injustice would be occasioned to the accused persons. 3, in the premises of this court hereby allows the application to amend the charges as prayed by the counsel for the state. So court clerk, you can take through the accused persons through the usual procedure.
We are going back to preliminary procedure, and retired Colonel Kizza Besigye, Captain Dennis Ola, and Obed Lutare. The language of court is English. Each of you is going to tell court the language is going to use. I'm starting with you, Fande Besigye. Which language?
We are availing a copy of the charge which is amended. Because once there have been amendments which were carried out, ideally the official preparing the charge and the court would sign, then it's a complete judgment which that is the one when we start the procedure our policy. We do not have that. And also, we have very good what we see, and we say we are the import is that so that we know what is coming, so that we are kind of request, because we haven't seen that, we don't know that it's there. And from what I can see, this website, I think my colleague because of this using cable.
The text will be read, but the good clerk is doing another thing, not reading the text. Good clerk, proceed with what you are doing.
I'm proceeding. Fande Besigye, the language of court. I'm back to you. Fande Besigye, the language of court is English. Now court would like to know the language you are going to use during your trial.
I guess I'm still before the same court, and I had indicated that I can communicate in English.
A1, English, sir. Afandola, which language?
English.
Andora, English. Obed Lutare, which language?
How did he came to number 2?
Eso in Ame, Eso Richa must follow his fellow soldier.
Wow.
Very Rutare, English. Fandi Besigye and Obey Rutare, your lawyers are known. Back to Captain Nora.
We can provide the list of the panel to your defense lawyers. I think immediate after here.
I think so, without wasting time, you can start, you say, General Freeman, Mugabe Chairman, and all other members. If we have reserve, they will also introduce themselves.
Is that what they are talking about? Brigadier General Robert Freeman Mugabe, Chair General Court Martial.
Major Richard Turihawe, I'm a member.
Captain Abdara Wasajawaraga, member.
Warrant Officer 1, Asimu Robert Nyarari, member.
Major Sala Sonko, member.
Lieutenant Colonel Samu Tungura, political commissar, member.
Captain Marion Akandinda, member.
Warrant Officer 1, Oyarbor Smart, member.
Captain Christine Natumbwe Sayuni, member.
Warrant Officer 1, Oyarbor Smart, member.
Now, question is back to you, Fandekano. Do you have any objection of any of the members who have introduced themselves?
Does the court have more members than have been introduced? Because if they do, we want to know all the members of the court, whether they are here or whether they are not here, so that we can object or not object, since they are interchangeable.
That's right, Colonel. There is Colonel Okarebo, who I'm not seeing today, and there is Captain Nekore. Yeah?
I think, sir, on our proceedings, the key issue is that the court is composed of 7 members. We have the members in reserve, they are present, and the court is duly constituted. So we'll go ahead on the next stage of responding to the questions.
The members of the panel, as duly established today, and those of 2 regards, will not change because our clients are objecting or not objecting to the ones who have been introduced. The requester expect that be the constant part.
Exactly, that is how it will be.
Mr. Chairman,
Yes, council, yeah, I have heard that. Yes. RO 1274, 3, Captain Dennis Ora, male adult Ugandan of sound mind, aged 48 years. Mr. Officer attached to Armored Brigade, a person subject to military law. A2 ROV, 0098, Colonel Retired Dr. Kizza Besigye, male adult Ugandan of sound mind, aged 67 years, resident of Kasangati Town, Nangabo Sub-County, Nansana Municipality of Akse District, a person subject to military law by virtue of Section 117, subsection 1G and HI of the EPDF Act, Cap 330. A3 Hajj Ubaid Rutare, male adult Ugandan of sound mind, aged 65 years, resident of Mutundu Parish, Makinde Sabagawo, Sub-County, Siro County, Akse District, a person subject to military law by virtue of Section 117, subsection 1G and H, I of the EPDF Act, Cap 330. A statement of offense on count 1. Offense is relating to security control, section 128, subsection 1F, the EPDF Act, Cap 330. Particulars of offense. Captain Dennis Ora, Colonel Retired Dr. Kizza Besigye, and Hajj Obeid Rutare between February 2023 and November 2024, while in the cities to wit Geneva in Switzerland, Athens in Greece, Nairobi in Kenya, and in diverse places of Kampala Metropolitan in Uganda, held meetings aimed at soliciting logistical support and identifying military targets in Uganda with intent to prejudice the security of the defense forces. Captain Dennis Ora, have you heard and understood the charge read to you on count 1?
Yes, I've understood.
Do you accept or you don't accept?
Madam Chairman, I seek your indulgence first on how to proceed. I've just gotten instructions at the bar to represent Captain Ola. I'm only privy to the amendment now. I humbly request that I interact with him and guide him. Thereafter, I shall formalize the instructions, if you please.
How long will that take?
Just a few minutes. About 2 minutes. Much obliged. Madam Chairman, we may now proceed.
Once again, Captain Dennis Ora, have you heard and understood the charge read to you on count 1?
Yes, I've understood.
Do you accept or don't accept?
I don't accept.
A plea of not guilty entered. Colonel Retired Dr. Kizza Besigye, have you heard and understood the charge read to you on count 1?
I have heard and I have issues with the charges which my lawyers present to you.
I think that you are addressed when time comes.
Mr. Chairman, we have objection to plea taking grounded on Regulation 23 of the regulations of this court martial, particularly sub-regulation 1, that before pleading to the charge, the accused may offer a plea to the jurisdiction of the court before taking a plea. The accused may raise the question of jurisdiction. Mr. Chairman, is on record. We have already raised issues to do with territorial jurisdiction of this honorable court. And there is a ruling which is pending before this honorable court, which is not delivered. That this honorable court has got no jurisdiction to entertain matters which are alleged to have been committed in Athens, in Switzerland, in Kenya. We have raised that issue before you, and this honorable court martial has not pronounced himself on the matter. So it will be a violation of Regulation 23 for the accused person to before the knowledge is delivered.
Are you not taking us consequence? Are you not taking us time? It is pre-taking. You can say yes or no. And then we can start from there.
Mr. Chairman, the rule is before pleading to the charge, the accused may offer a plea to the jurisdiction. That is the rule, and this is what I'm quoting. And oftentimes these court martials reminded us to abide by these rules. And the judge advocate is so passionate about these regulations. I hope this time round is going to appropriate the advice of this honorable court martial, that it's within the accused's right not to take a plea until the ruling is delivered.
I'm reminding the Council of Karua that the accused himself raised that objection. I'm the one talking. No, you cannot object when I'm talking.
Can you listen and finish what is?
You have not raised anything.
You have not listened what that is saying. Now what are you objecting? Without even listening to what he's saying.
I can confidently tell this court and those who are present that the matter was raised and the court ruled on the matter. Registrar, can you avail the ruling that was raised objecting to jurisdiction by this court? Just to remind you, you read the ruling and when it was delivered. I will proceed.
Please, order he went to the that was not stop you from submitting on what
My Lord, with your permission, I proceed with the ruling that Public of Uganda, Uganda People's Defense Forces, the General Court Martial, Coordinator Makinde, criminal case number UPTF, ECM 040-24. Uganda, represented by prosecutor versus A1, ROV 0098, Colonel Retired Dr. Kizza Besigye, A2, Hajo Bet Utare, accused person. Ruling on application made by Counsel Erias Lukwago.
Ruling raised on the jurisdiction of the court, not the one of Lukwago. The one of Lukwago is not yet ready.
We are also interested in that one. If it is ready, we have been asking for it since morning.
I think if you don't have it, either you go to consult your files. But I know that the ruling was out.
Why are you standing following? No, sit council, the first signature. Get that ruling registrar so that we don't waste, we have taken time. That ruling is there.
Nakugambye kateeke wano ng'okateeka eri oli wano.
Why do you insist you want it now? When the court wanted to read it, you didn't want it. Now we are on retaking, I mean, the charge you want the ruling.
But you say they read it.
I think, sir, for me, as judge advocate of this court, the registry is even under my office, and I am reading it is here. I have not written it now. So the ruling was pronounced by the court. It is that who raised it himself on day one. So it shouldn't be a point of saying that you are raising it now. What ruled on it?
Oh, most obliged, thank you.
I'm not saying the objection. Accused person is objection. Where is the objection? When was
My Lord, on 20th November 2024, A1, by then was retired Colonel Dr. Kizza Besigye. He objected to all the court members.
Yeah, I fail to understand. Do you think he's reading what is not written? I thought you were supposed to be ordered and seated.
He objected to all the court panel and jurisdiction. Even A2, who is now A3, raised the same objection. J guided that the accused have to give reasons for the objections as regards to the court's panel and jurisdiction. A1 stated that it's a military court and I'm not a member of military. I believe I should be tried by civilian court. A2 stated the same. JA guided that state had to give a reply to the objections. State replied as follows. It has for my lord. It captures the concerns on jurisdiction.
Helpful, let him.
Had the background. States have admitted that the object is one, the objection is one, and in reply they stated as follows. That the enabling law, which is section 117, applies to all the accused persons, that is A1 and A2 as then were referred to. He also proceeded and stated and informed court that he did not even know the lawyers that were representing the accused persons. Then JA guided that court had to close for the deliberation and make the ruling. Counsel Lukwago submitted that they had no opportunity to meet the accused persons to hear their story and get full instructions. He asserted that lawyers as of practice, they proceed with instructions. He proceeded to tell court that A1, as then was Dr. Kizza Besigye, and his colleague by then was A2.
Those are different issues now. Because for me, I'm always in this court. And what I have is that court adjourned to make the ruling on the objection. Court came and gave the ruling, and I have the ruling here. The court said they are subject to military law under section 117G and H of the UPDF Act. That was the ruling of court.
Mr. Chairman, the judge advocate by law is not a record keeper. He cannot assume the role of the registrar with respect, and therefore the registry is under your office, but you cannot, the law does not allow you to come to court and be an advisor as well as a record keeper.
I'm the one who supervises the record.
My lord, the ruling briefly is that after 5 minutes deliberation.
Mr. Chairman, with your permission, if I may just correct my friend from the registry. When we were here last week, court adjourned the handing down of the ruling so that we could consult the accused persons, who were two at the time, regarding the instructions of counsel to receive the ruling. It might be recalled, Mr. Chairman, that when court asked or pointed out to my senior colleague, Mr. Lukwago, why there should be an adjournment, we did point out that we who were present, myself and Mr. Katumba, in the absence of Mr. Kalibala, who were counsel on the record at the time, were not in court when those objections were made. when we returned, the court adjourned to today without delivering the ruling and moved on to determine the matter of Mr. Aaron Kizza. So there was no handing down of the ruling. Now, my concern as counsel for the accused persons is that we understand that it should be the court to hand down the ruling. When the judge advocate insists that his office has the ruling, which has not been handed down by court, Mr. Chairman, it points to the impartiality of court, and any other person who follows these proceedings on TikTok and whom will only see this caption might think that it is the office of the JA which perhaps writes the rulings for the court. I think that is a grave concern which we need for the sanctity of these proceedings to remind ourselves the role of the court and our land colleague, the judge advocates. Otherwise, it is not little, it is of much concern, Mr. Chairman, when the registry, which should be the central collection of proceedings for the day, appears to have no ruling. The court, led by your leadership, Mr. Chairman, does not recall reading or has no ruling. And yet, the advisor of the court insists that for him, he has the ruling. It is, again, Mr. Chairman, we did remind ourselves that we, as lawyers, may understand the omissions, but to someone who is in the dock, who is a businessman, a doctor, a gallant soldier, who doesn't understand these proceedings, might think that this is a prearranged session. It is a little of concern, and again, I wouldn't want, because it would be the third time, sometimes rather than going what we are going through, perhaps the court to retreat a little just to put its house in order, because now we are pulling rope and it doesn't appear quite nice, Mr. Chairman. It's my plea and my request, Mr. Chairman.
My lord and members, maybe to make it clear, on the first day, the accused persons were not represented, and that's when they raised the objection of jurisdiction. And on the same day also, Lord Mayor, as then was, now is the council, also raised objections. So there were two rulings. One was given, another one was pending. So the one that I'm reading today was giving the background of what happened in the court, and then the another one you haven't given us to read it. So I pray to proceed with the one on jurisdiction that was raised by accused persons at the time who were not represented. While citing section 117 of the UPDF Act Cap 330, court ruled that this honorable court had jurisdiction and has jurisdiction over the accused persons since they are all subject to military law by virtue of the same section and ended there. And he proceeded and read the charges to the accused persons, to which they all pleaded not guilty. And then that's when Lukwago, Erias, with due respect, by then was not counsel, had no instructions, proceeded and also raised some objections as pertaining to the charge sheet. That's what we have.
So I think I am vindicated. Yes, because my report is starting with the one of registrar. Why are you saying that I'm writing my own things?
That one was finished. Let us proceed.
Mr. Chairman, your permission.
I was counsel said. I was asking the Colonel that Kizza Besigye, have you had understood the charge read to you in count one?
I have heard and I have responded that I have objections to taking plea on this charge and requested my lawyers present my objections.
You are right, but at this moment I'm asking you, the chosen person, if you don't accept, you say I don't accept. If you accept, you say yes, I accept.
Accept what?
There are two things. If you have had understood, another question is, do you accept or you don't accept?
Accept what?
Your help to you, Mr.
Do I
Chairman.
plead guilty or not guilty? Or you want me to take a plea?
He has invoked Rule 23 that he is objecting to taking plea.
Yes.
And therefore it may not be fair to ask him whether he accepts when he clearly invokes Rule 23 and it allows him to do what he is doing. So maybe you could allow, on his behalf, Counsel Erias Lukwago to raise the objections on his behalf as he has asked us to do, instructed us to do.
I think, sir, they are taking us backwards. Exactly. That's what the registrar has read. It's the same objection that was overruled. So we cannot go back to where we started before.
Please, no, I've not allowed anybody now to talk.
Thank you, Mr. Chair.
Because now you are taking us back and it's true. It is a new charge. Now what if side just now the one you are pushing for is corrected? Will he accept or he will not accept? So the issue is we have read the charge sheet. It is the chosen person to plead guilty or not to plead guilty, and then you can start from there.
Thank you very much, Mr. Chairman. Mr. Chairman, my learned friend, the JA, rightly pointed to the court adopting rules of amendment of criminal charges, and also pointed out to any amendment which can be done which doesn't prejudice the accused person. That is correct, and it's on that basis that the court made a ruling regarding the amendment. My colleague will agree that once an amendment has been made, the process which was running before comes to an end and starts afresh with the new amendment. The charges we have now, clearly, from looking at the amended charge sheet dated today and the one before, are distinct. So essentially what the prosecutor has done is to start again the process which started in November. So the objections which were made then, if any, cannot be carried on by infection to the current charge sheet. To the extent that the accused person has seen and has new objections, because this is now a fresh charge sheet, Mr. Chairman, as the JA will agree with me, they are entitled to make the objections. They might be boring, they might be the same, they might be repetitive, but in a dispensation when we are saying it is his right, it is his right to make the objection. What we request is for court to listen kindly, and then also, as my learned friend has advised, and the JA, if we do it together, Regulation 23, kindly. It says, Mr. Chairman, before pleading to the charge, the accused person may offer a plea to the jurisdiction. And if he does so, the accused person may adduce evidence in support of the plea, and the prosecutor may adduce evidence in answer to that evidence, and the prosecutor may address the court in answer to the plea, and the accused may reply. Mr. Chairman, Regulation 23(1) applies before taking a plea. It is not even saying at the time, it says before. It also says that the accused person may. When it applies may, Mr. Chairman, it gives the accused person a discretion. What we understand now, Mr. Chairman and members of the court, is that the accused person has chosen to exercise their right to raise an objection. We have not listened to the objection because according to the accused person in the dock, he has asked his lawyer to make the objection. So my lord, in that regard, we would be inclined, if we are to agree that we follow this procedure of this court, we are enjoined to listen so that the state may respond, and then the court will make a pronouncement. That is what, Mr. Chairman, we understand from the clear. It is before. So, Mr. Chairman, when the accused is asked whether he understands, we understand that to be part of the plea-taking process. Yet the rule requires that before that process begins, he has the right to raise the objection. We humbly pray, Mr. Chairman, that we abide by this regulation. We kindly request, Mr. Chairman. Thank you, Mr. Chairman.
I also concur with the council FK. You raise your objections, let the state reply.
Violation of Article 23 and 28 of the Constitution of the Republic of Uganda. If you proceeded to entertain this matter. Mr. Chairman, the Constitution confines the jurisdiction of this Honorable Court Martial to matters relating to offences allegedly committed within the territory of Uganda. Mr. Chairman, under Article 23, 28, yeah, yes, 28:12, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it prescribed by law, and also yes, I'm coming to Article 28(7) as well. You read, if I may be permitted to make my case. No person shall be charged with or convicted of a criminal offense which is founded on an act or commission that did not, at the time it took place, constitute a criminal offense. Mr. Chairman, when you look at the charge sheet, the particulars allege that while in Athens and in Greece, rather in Geneva, Switzerland, and also Kenya, in Nairobi, Kenya, the accused persons are alleged to have committed those offenses, particularly the allegations that they were found in possession of weapons which are ordinarily a monopoly of defense forces. Mr. Chairman, weapons in Kenya, or military hardware in Kenya, or Athens, or in Geneva, cannot be a monopoly of UPDF. The UPDF Act specifically talks about weapons which are a monopoly of UPDF, not the defense forces or security forces of Switzerland, of Greece, or of Kenya. When you look at the provisions of Article 28(7), those acts, the impandi acts spelled out in the charge sheet, would only constitute offenses in those countries, either in Kenya, in Switzerland, or in Greece. Because, Mr. Chairman, the particulars here, they are talking, Colonel Dr. Kizza Besigye, while at Riverside apartment in Nairobi, Kenya, were found in unlawful possession of a pistol model this, which is ordinarily a monopoly of the defense forces. Mr. Chairman, this one has two limbs.
One, defense forces are not defined. Are you talking about the defense forces of Uganda, of Kenya, of Greece, or of Ethiopia? They are not defined here. And that is one of the functions, but also on regulations, particularly Regulation 22. Regulation 22 provides us for an accused may, before pleading to a charge, object to it on the grounds that it's not correct in law or that it's not framed in accordance with these regulations. And if he does so, the prosecutor may address the court in answer to the objection, and the accused may reply to the prosecutor's address. This is Regulation 22 of your regulations here. An accused may, before pleading to the charge, object to it on grounds that it is not correct in law and that it is not framed in accordance with these regulations. So, this is a defective charge sheet. This is our contention here. That it's not framed in accordance with the UPDF Act. It's not framed in accordance with the UPDF Act 2005 because purporting bring into the confines of this court, the jurisdiction of court, matters which relate to weapons of other countries, defense forces, in this case here, that is penalty defense forces or elsewhere. Because if it were a charge relating to offenses under the UPDF Act, specifically they will be stated here that contrary to a particular provision which talks about multiple points which are ordinarily a monopoly of the UPDF. But here they are going to contrary to defense forces. So the presumption is that court martial has jurisdiction all over the world. That is universal jurisdiction. That whoever is informed in possession of any weapon which is alleged to be a monopoly of defense forces, not UPDF, for defense forces worldwide, then this honorable court martial has got jurisdiction in that. So that offense, regulation 22, and the charge sheet becomes effective. It's not correct in law, it's not framed in accordance with the UPDF Act. Then the other limb of the argument, Mr. Chairman, is in relation to the way the accused persons were transferred from Kenya and from here. Mr. Chairman, our contention is that this honorable court has been jurisdiction whatsoever to deal with accused persons who are not processed in accordance with the laws of Uganda or who are handled in a manner that violates international law. And I will refer you to a number of authorities which we have here. Mr. Chairman, I have the Ugandan case of Omar Owadi and 10 others versus the Attorney General. The consolidated constitutional petition number 55 and 56 of 2011. And Mr. Chairman, difference was made a number of decisions that have been taken by other countries. First of all, Mr. Chairman, in made difference in the case of Regina versus Osipe Royal Magistrates Court in 1994, SC Volume 1, page 42, where the House of Lords gave a genesis to the jurisprudence relating to matters of this nature. And this is what they have to say. English common law regarding irregular apprehension of an offender abroad and the jurisdiction of English courts to try such an offender was examined by the House of Lords in that case of Regina versus Osborne. The earlier approach of the English courts has been that once a suspect is in lawful custody, that suspect, and charged with an offense, which that court has jurisdiction here, the court has no power and is not concerned with required into the circumstances in which it may have been brought into its jurisdiction. It was no answer to a charge that such person was arrested or put up contrary to the laws of the state of refuge. That was the jurisprudence and the practice as I obeyed. And the House of Lords had to pass that position, and this is what it has to said. This is now the common law position on issues to do with the people.
uniformity of nations and the rule of law generally. There is many difference in the aforesaid case of Regina. We observe that courts in this country have scrupulously reaffirmed the need to observe the rule of law and prevent the abuse of the court process. The case of Dr. Kizza Besigye versus the Attorney General has held that this court is obliged to intervene and even state proceedings where the abuse of the court process is such that no fair trial can be achieved. This principle is affirmed by the Supreme Court in Kizza Besigye and others versus the Attorney General, Constitutional Appeal number 1 of 2006. This is the position the Constitutional Court adopted one in this case, but also the position that has been well established in all Commonwealth countries or jurisdictions. That once the accused persons are illegally brought before court in violation of international law and they have been kidnapped and illegally extradited, then that court has no jurisdiction to deal with the same. We are making reference to the Extradition Act, a copy of which, Mr. Chairman, I'm sure you have, which clearly makes provisions on how accused individuals or citizens of a particular country, Ugandans, who are alleged to have committed offense outside the country, are supposed to be transferred back to the country where they should be charged. One, this Extradition Act, Mr. Chairman, talks about a fugitive criminal. That one must have been a fugitive criminal to be subject to extradition. It's abundantly clear that at no one moment has this court-martial been presented with a record that prior to their production before this court, that they were criminals, they were fugitive criminals who had pending charges that required their extradition. And even if that were to be the case, Mr. Chairman, the Extradition Act provides for the procedure on how this should be done, which involves the judicial process. That we go through the processes of the judiciary in Kenya, where they were arrested from, present them before the law, the warrant is made, and upon a request made by the domestic minister here to the counterpart in Kenya, requesting that commence the process of extraditing that fugitive criminal who is within your territory, your jurisdiction. That is what is provided for in the Extradition Act that we have here. This was never the case. There were no extradition proceedings in Kenya, and therefore they were not legally transferred back here. The other option would be deportation. Mr. Chairman and honorable members, if indeed they were found to have entered Kenya illegally, or if they entered Kenya illegally and committed the offences as alleged in the charge sheet, that they were found in possession of firearms, which are ordinarily a monopoly of defensive forces, this would be the defensive forces of Kenya. That would constitute an offense in Kenya, and they would be prosecuted in the courts of Kenya. And if the courts of Kenya deem it necessary and appropriate to have them deported to their country of origin, they will issue those court orders. That so Dr. Besigye and Abel having committed such and such offense, you are hereby deported. There is no deportation order, there is no extradition warrant. So these accused persons were illegally brought here before you, and now the charge sheet prepared is in reference to offences allegedly committed in Kenya. The authorities we have cited here are very, very clear that we do not have jurisdiction
in such cases. The one we have talked about of South Africa, it involved illegal rendition of a particular individual from a neighboring country to South Africa. You'll find it, the facts you'll find them in that particular case. The case was dismissed. You see, this is legal because since there was kidnapping this particular individual from a neighboring country and brought to South Africa, they couldn't be tried in South Africa. It is the case here. Now you are being asked, Mr. Chairman, to entertain and try a matter which did not go through those legal processes, which is a violation of international law and a violation of our constitution, and essentially the proceedings rooted in nullity where we do not have jurisdiction to handle this matter. So that is our contention in this particular case, and it is the reason we are saying at this stage, under Regulation 22 and 23, Dr. Besigye and Dr. Besigye are not taking the charges which are penalty charges, which are criminals, charges which offend the laws of Uganda and international law. So we pray that you be pleased to strike out the charge sheet, and discharge their chosen persons. We do so pray.
If I may add to that, just to confirm that the extradition law of Kenya is similar to that of Uganda, that the constitution of Kenya is similar in terms of rights and the requirements of due process to the constitution of Uganda. In both countries, due process is emphasized. And therefore, as has been ably demonstrated by Counsel Erias Lukwago, the fact that agents of the state of Uganda arrested or abducted the two gentlemen from Kenya and brought him back without any court order from Kenya. Because even where the states have an extradition treaty, you still have to present a person to the court in the country of arrest. So they ought to have been presented to a court in Nairobi, and that court is the one that would have ordered for their being brought to Uganda. In that court, these two gentlemen would have had the opportunity to object to their being brought. They would have had a say. But now they were brought against their will. And the state, the arresting authorities, have actually violated the constitutions of Kenya and laws, the constitution and laws of Uganda, and the laws of the East Africa community. The Constitutive Act, Article 6 and 7, the rule of law principle, has been violated by renditioning Dr. Kizza Besigye and Obed Rutale from Kenya. What if the arms alleged to belong to defense forces belonged to the defense forces of Kenya? Would it be a criminal offense triable in Uganda? Those are the issues. That's why in each country, jurisdiction, you have no jurisdiction, because the constitution of Uganda says so. The jurisdiction of the courts in Uganda is for Uganda territory. So we are asking you to strike out these charges so that our clients do not have to plead the defective charges, and to also put weight on the submissions of Erias Lukwago, on the fact that even if you had jurisdiction and we submit you do not, the fact that they were illegally brought here. The state is not permitted in law to commit a criminal offense or to violate the law in the name of apprehending offenders. You cannot violate the law under the guise of enforcing the law. Bringing them without a court warrant, from Kenya, without extradition and a court order is a violation of the law. And therefore these charges cannot be entertained. The second schedule to the Constitution of Uganda clearly says, and it's pursuant to Article 5, it gives the boundaries of Uganda. I will not read, it's a long description of the boundaries of Uganda, but I refer you to it so that you find Nairobi is not within Uganda. And any offense committed in Nairobi is up to the authorities in Nairobi to prosecute somebody in the courts of Kenya. So you are being asked to take plea on a matter for which this court-martial and all courts in Uganda have no jurisdiction whatsoever. If it is in Athens, the courts in Greece will have jurisdiction. If it's in Switzerland, the courts in Switzerland will have jurisdiction, not the courts in Uganda. And the UPDF Act, made pursuant to the Constitution of Uganda, cannot amend the Constitution of Uganda. So if the Constitution gives territorial jurisdiction of the courts as Uganda, the amendment of the UPDF Act, which seems to expand the jurisdiction of this court beyond Ugandan territory, is unconstitutional. It must defer to the Constitution, and these charges must be thrown out. I give way to any colleague who may have something to add.
Honorable Chairman and honorable members, just to supplement, we are alive with the
My Lord, maybe before the supplement, we wait for the JA. Because
he's absolutely
in charge of payments on the land procedure.
In case there is anything concerning, let's wait for him.
Supplementing to what my colleagues have submitted, we are also alive to Section 208 and 209 of the Act. Those two sections appear on the face of it to grant jurisdiction for cases outside Uganda, but we contend that if that is the interpretation given by this court, those sections, then they are inconsistent. Two articles in the Constitution, Article 79, the powers of Parliament, which are restricted to good governance of Uganda, and Article 129 that my senior colleague has read, on the exercise of judicial power of Uganda. So the finding of the court, the view of the court is that those two sections do away with the objection that we are raising. We are given advance notice that we will see interpretation of those two sections compared to section.
They must be here with us. They can't just come through a pipe without them. They have to be here for that provision. If the view is that they can be tried under 208 and 209, as I have said, we will be moving next.
First of all, Chairman and board members, jurisdiction was earlier Richard starting. And as Mr. Karua put it, section 208 of UPDF Act empowers us, which means that the person alleged to have committed the service offense may be dealt with and tried under military law, whether the alleged offense was committed in Uganda or out of Uganda. And we are saying Greece, Kenya, and Switzerland, indeed they are out of the country. But it is provided by the law. And it is not this court that has those powers to repeal this law. When this law was passed, I believe Council would have been one of those that were in parliament, probably have boycotted the parliamentary sessions, but it was there, it is there. There is that post. I don't know whether he really read it, and it is not in this court where he can bring unconstitutionality. Yet he knows where it is supposed to be in case it is unconstitutional. Section, so that one, in regard to the jurisdiction, Chairman and court members, we have the jurisdiction. You also talk of defense forces. Is it the defense forces of Kenya, Switzerland, and where? The act here defines what defense forces is. Section 2 of UPDF Act Section 1 defines defense forces means the Uganda People's Defense Forces. So these people, the suspects are charged under the UPDF Act. Therefore, there is no question of saying, these Kenyan People's Defense Forces, is it a group of Switzerland Defense Forces? The Act is very clear. Chairman and court members, Section 117G gives powers to this court, the court martial, to try people who are not otherwise subject to military law, but become subject to military law. That is, every person not otherwise subject to military law who aids or abates a person subject to military law in the commission of the service of defense. And H, every person found in unlawful possession of arms, ammunition, equipment, ordinarily being monopoly of the defense forces. And the defense forces is already how these people appeared before this report that it was unlawful. Unless you do this otherwise, we do and we are contented that these people were brought here lawfully. Other than the extradition, there are other interstate arrangements which are in place that between the two countries on your border, in the border line to do with terrorism and security related matters. There is a memorandum of understanding between the two countries and this is so, to do with how the accused persons arrived here, chairman and one of the board members was an interstate arrangement that became so the constitutionality question, chairman and one of the board members, that contravenes the Constitution, which I believe is not there, because Senior Counsel Karua was quoting the Constitution that it limits, it provides employment in the region, but she did not quote the particular provision. Territory. No. So it is not applicable in this matter. I hand over to my colleagues.
My Lord Chairman and Honorable Court members, I begin with to respond to Honorable Erias Lukwago's submission on the propriety of the charge sheet regarding Regulation 22 of the UPDF Rules of Procedure Regulations. Honorable Lukwago is of opinion that the charge is defective and duplex, and says it does not comply with the regulation. Mr. Chairman and members, in making his case, he did not refer to which regulations the charge sheet does not comply with. Reading Regulation 22 that he cited, it talks about compliance with the regulations, these regulations. And my lord, in the regulations, framing charges is governed by Regulation 6, Regulation 7, 8, and 9. And Counsel Lukwago has not shown how these provisions are violated by this charge sheet. Counsel Lukwago also says the charge sheet is duplex. Our understanding of a duplex charge is one which introduces two charges in one count. But his submission has not spelled any such in this charge sheet. So we maintain that the charge sheet is proper. Honorable Counsel Lukwago, together with Senior Counsel Karua, talked about the production of the accused persons before this court as being illegal. However, Mr. Chairman and members, the issue of illegality and that's what we shall establish if this matter comes to hearing. It is not a matter that can be just determined at this point. And their decisions, Honorable Lukwago also relied on the House of Lords decision on the Regina versus Hospital districts. On how the House of Lords departed from the common law position. Mr. Chairman and members, we respect that decision, but it applies to the law in England. It is not the position in East Africa. The position in East Africa, we have case law. We have a Tanzanian decision of Mataka versus Republic, a reported East African case. Where the East African Court of Appeal pronounced itself that once a person has been brought before the court, the issues of how he was arrested do not bar trial. It is reported in 1971 East African Law Reports at page 497. The issue regarded one of the accused persons called Mr. Chipaka, who was charged with treason. I also associate with my senior friend for the state about the position on extradition law. We maintain that extradition law is not the only mechanism of dealing with trans-border crime. There are other mechanisms like interstate arrangements, and they are also authorized by the East African protocols. Mr. Chairman and members, I invite my colleague to handle the submission.
Lord Chairman, I will not have much to say, but I see my colleagues' submissions. Lord Chairman, we read what the senior colleague said about section 208, the Refugee Pact, as far as the unlimited jurisdiction of EPDF is concerned. But also, under that section, there is something to do with service offense. And the service offense is defined under the EPDF Pact. Under section 1, section 1, which service offense means an offense under this act or any other act for the time being in force committed by a subject while subject to military law. Now, Chairman, that is very important, especially subject to military law. Under the charge sheet that we intend to amend, the accused persons are subject to military law, specifically under section 117. subsection
person subject to military law, and my lord, we proceeded under section 1G, but also H of the IPF Act. And offences with which they are charged are provided for under the IPF Act. So my lord, one has such is not provided for, intended to lastly, my Lord Chairman,
the reading of section 22,
section 23, which the regulation 23, which my colleagues cited, I think it's something clear that before taking plea, the charge, plea to the charge, the accused may offer a plea to the jurisdiction of court, and if he does so, the accused may adduce evidence in support of the plea. But Chairman, what we only heard from my colleagues was not evidence, because evidence is defined. And my Chairman, they never laid any evidence whatsoever that would not only persuade, but also convince this court. So it's only them, information is to them, and it is argumentative that the persons are wrongly before this court. No evidence whatsoever that they are wrongly before this court. So, my Chairman, I pray that we don't entertain such submissions which are baseless, but also, which are not only baseless, but also not grounded in law from the section that they have read. My Chairman, lastly, I associate myself with what my colleagues said and will reiterate our submissions that we be pleased to not to allow the objection. And the Chairman is okay. We have a good feedback, Mr. Chairman. One, on the issue of the applicability of the House of Lords decision, or the common law position, which has since changed. I find it strange that my learned friend in charge of prosecution of this case did not take any interest in the Ugandan authority that I cited, which is Omar. Our is the 2011 Constitutional Court decision. I will give a copy to you, Mr. Chairman. He cited a number of Commonwealth decisions without proof. So I only mentioned a few. And specifically, he's talking about the one of Tanzania. Mr. Chairman, it's got a lot of problems. It is also canvassed here, but it was distinguished in this particular decision by the Constitutional Court. And the Constitutional Court upheld, rather was persuaded by the decision in Ibrahim, or State versus Ibrahim, the South African decision of 1991. And the facts are almost on all fours with this one. If I may give you the facts briefly, the South African Court of Appeal allowed an appeal against the conviction of the appellant for treason. The appellant, a member of the military wing of the African National Congress, who had fled South Africa while under a restriction order, had been abducted from his home in Swaziland by persons acting as agents
of the South African state and taken back he was a member of the military wing of the African National Congress who had fled South Africa while under a restriction order and had been abducted from his home in Mbabane, Swaziland, by persons acting as agents of the South African state and taken back to South Africa, where he was handed over to police and detained in terms of security legislation. He was subsequently charged with treason in the circuit court. And the appellant had, prior to pleading, applied for an order that court lacked jurisdiction to try the case, as his abduction was in breach of international law and thus unlawful. This is a precedent which is on all fours with this, and the court had the occasion to say this. We note that in this instant case, the state of South Africa violated the territorial integrity of Swaziland by sending its own police to abduct the appellant from Swaziland. The South African Court of Appeal also considered that it had no jurisdiction to try him, given the breaches of international law that South Africa had been privy to. Therefore, they said, therefore, the other Tanzanian case which is cited here is distinguishable from this one. So I invite this General Court Martial to treat that as a redundant submission because it has no basis in the law. And the decision that was made finally in that particular matter is what I read earlier, that court has no jurisdiction to try a person who was abducted from another jurisdiction by agents of the state authority, exercising power in the area of jurisdiction of the court. That puts this matter to rest, and this is a court. The defectiveness in the charge sheet, it cannot be, and it would only be a monopoly of UPDF. And even here locally, by the way, Mr. Chairman, there are authorities to the effect that the pistol is not a monopoly. But those are matters that can be handled at a later stage. It's not a monopoly of the UPDF, a pistol and ammunition. Now, on the question of an MOU, wouldn't it be a submission coming from lawyers who went to the law school and they are here dealing with matters of this nature, brave as they are? Because, Mr. Chairman, we are talking about matters of life and death. And you are talking about an MOU to override a written law. When you look at this act, the Extradition Act, which commenced on the 20th of July 1964. In the long title, Mr. Chairman, an act to provide for the extradition of persons accused or convicted of crimes committed within the jurisdiction of other countries. This is an act. An act, this is the wrong title, an act to provide for the extradition of persons accused or convicted of crimes committed within the jurisdiction of other countries. This was not made in vain. This is the only framework we have under the law that can be invoked to have an accused person transferred from Kenya to Uganda. There's no any other framework, legal framework. I wish they cited the law under which that employee was executed. At least even laying it on the table that this is the employee. And the law which provides for elaborate mechanisms you have to go through before you get one transferred back to Uganda. And you are saying that one can be jettisoned by a mere piece of paper called an employee. Mr. Chairman, that should be treated with the contempt it deserves. On my side, the final submission, Mr. Chairman, the issue of Article 2 or Section 208 and 9. Section 208 of the UPDF Act. Mr. Chairman, this law, this particular provision, was not meant to operate in isolation of other legislations. No. It had to operate first and foremost within the existing constitutional order, because the Constitution is supreme. My learned friend here, Senior Counsel, and my brother Karua here, they have cited the relevant provisions of the constitutions which are which take precedence over any other legislation. But even then, the UPDF Act comes into play after you have complied with all these other requirements, with all these other laws, the extradition law, the Constitution, and all this. So that's when it comes into play. But if you cannot cling on one particular provision and say, it gives us universal jurisdiction over all matters worldwide. So the other argument that we have not particularized the defects in the charges are equally neither here nor there. Because, Mr. Chairman, we clearly indicated that the charge sheet, the way it is structured, when you look at it on the face of it, you can see the defects, the charge sheet itself. Because, yes, my learned friends have cited section 6, 7, and 8, which talk about the particulars of the charge sheet. Exactly this is the point we are raising in this amended charge sheet here, where they are stating that the county 4, county 3, and 4 together with actually county 5, where they are talking about rounds of ammunition and a pistol. Here we reiterate our earlier submission. We are saying this particular, these particular counts do not play out the acts, the impending acts of the committed by the accused persons in regards to the defense forces here in Uganda. This is the point we are making. The impending acts in regards to the defense forces here in Uganda. Let me say it differently. If indeed they wanted this section 2.8 and 2.9 to come into play, they should have expressly stated that they were found in possession with the firearm, with the pistol and ammunition, which are a property of the government of Uganda. If that's what they had said, that would be a different case. That which are a property, subject to proof of course, which are a property of the UPDF. That would be their case. But it cannot be sufficient to say that whoever is found in Kenya with a pistol and ammunition, you offends the UPDF Act. There are so many people in Kenya right now who with pistols and rounds of ammunition. Would they want to suggest that those are all subject to martial law here in Uganda? This is the absurdity we are talking about in this charge, that it's not particularized, and it is duplex in nature, that it purports to bring all these issues of ammunition, of the pistol and whatnot, all lumped together to make it as if it's one count which is put here. So basically, on the question of evidence, as I wind up, Mr. Chairman and honorable members, that we should have raised evidence before you regarding the way they were transferred here. Mr. Chairman, the charge sheet speaks for itself. The record is very clear before you that all they are complaining about, all the issues they are raising, Kenya, Switzerland, and elsewhere, there is no single impande act here that offends the law which they are put in the particular of the charge sheet. Nothing. So all they are talking about are acts which are alleged to have been committed in Kenya. And in this particular case, Mr. Chairman, and in this particular case, Mr. Chairman, we want you to find that these acts complained of here can only be, first of all, processed by those respective jurisdictions. Kenya, Switzerland, or Greece, but not to be directly brought here before you. I ask my colleagues if there are other specific issues to respond to come in. I thank you, Mr. Chairman.
Just a single issue with your permission. The prosecutor says that, or rather, the prosecutor says that how the accused were brought here. I don't think so. It is once the defense raises an issue on how the accused were brought, it's up to the prosecutor to then rebut by showing the court that they were brought here. If there is an MOU, let it be laid on the table. I have cited the extradition law of Kenya. It's Cap 75 and it is online. Anybody who is being extradited, even if they are willing, they have to go before a court so that an order is issued. So if they have an order, let them show it. If they have an MOU, let's look at it and see whether it fulfills the order. We've also cited Article 129 of the Constitution of Uganda, which limits the territorial jurisdiction of all courts, the courts of judicature and courts named under an act of parliament, and that's where this court martial falls. There is no other statute that can be greater than the Constitution. So the Constitution limits you to Uganda. Therefore, kindly discharge this thing. And let us all.
Mr. Chairman, if you are having the latitude, the prosecution has miserably failed to defend the charge sheet. Mr. Chairman, the prosecution has averred that indeed, although the rendition was illegal and unconstitutional, there are other mechanisms through which they can have the suspects brought in Uganda. Incidentally, Mr. Chairman, the prosecution has conceded that indeed, actually it is an admission that indeed the state committed illegalities and constitutionality while bringing back the two accused persons, Dr. Kizza Besigye and Erias Lukwago, back to Uganda.
Mr. Chairman, I implore you and your entire court, the entire panel, that find it no difficult while stretching out the charge sheet, throwing out all the allegations, Mr. Chairman. Mr. Chairman, set our clients free. There is nothing to prove.